All right, good afternoon. Looks like everyone is here, so we're going to go ahead and get started. As you all are aware, the proceedings will be live streamed to the public, and we've already started the live stream. In addition to the live stream, this hearing is being recorded. The transcript and the video recording are part of the public record and will be posted on the Office of Tax Appeals website. As discussed at the pre-hearing conference, please make sure that you don't show any private or sensitive information on the screen. Today's hearing is being heard by a panel of 3 administrative law judges. I'm Judge Ralston, and I will be the lead judge. Judge Brown and Judge Kim are the other members of this tax appeals panel. All 3 judges will meet after the hearing, and we will produce a written decision as equal participants. Although I'm the lead judge, I will conduct the hearing. Any judge on this panel is free to ask questions or otherwise participate to make sure that we have all the information that we need for this appeal. Also present is our stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Even if you think you know what I'm going to ask, please just wait for us to finish asking the question. Also speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The pre-hearing conference in this matter was held on May 19th, 2025. At the pre-hearing conference, respondents submitted exhibits A through H. And appellant, Mr. Shahatit, indicated that he had no objections to respondents' exhibits A through H. Is that still correct, Mr. Shahatit?
Yes, ma'am.
Okay, thank you. And the appellant submitted exhibits 1 through 3, and respondent had no objection to appellants 1 through 3. Is that correct, Mr. Samara Wikrima, that you have no objections?
Yes, Judge.
Okay. So the appellants exhibits 1 through 3 and respondents exhibits A through H will be admitted without objection. Both parties stated at the pre-hearing conference that they did not intend to call any witnesses. Is that still correct?
Yes, ma'am.
Thank you. And CDTFA, no witnesses?
That's correct, Judge.
Thank you. As far as the course of the hearing, Mr. Shahatit, you will go first and you will have 30 minutes to give your presentation when we get to that point. Mr. Samara Wikrima will go next and you will also have 30 minutes to give your presentation. And then we will give Mr. Shahatit 5 minutes for rebuttal. So I think we're ready to go on the record unless anyone has any questions for me. Doesn't look like anyone has any questions. Looking at Ms. Alonso, my co-panelist, are we ready to go on the record? Okay, great. We are now on the record in the appeal of Excel Food Services, Inc. This matter is being heard before the Office of Tax Appeals. The OTA case number is 221111940. Today's date is Thursday, June 26, 2025, and the time is approximately 1:52 p.m. First, I'm going to start by asking the parties to please introduce themselves for the record. Please state your name and who you represent, starting with Mr. Shahatit.
My name is Nader Shahatit. I'm representing the business of Excel Food Services.
Thank you.
Nalan Samara Wikrama, hearing representative for the department.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Chad Backus, attorney with CDTFA's legal department.
Thank you. As stated, the pre-hearing conference in this matter was held on May 19th, 2025. Appellant has submitted exhibits 1 through 3 and respondent had submitted exhibits A through H. Appellant's exhibits 1 through 3 and respondents exhibits A through H are admitted without objection. Neither party intends to call any witnesses. The time estimates, each party will have 30 minutes for their opening presentation, and then Mr. Shahatit will have 5 minutes for his rebuttal. Looks like we are ready to proceed with the opening presentation. So Mr. Shahatit, you have 30 minutes. Please begin when you're ready.
Yes, ma'am. Let me start with what is the purpose of sales and use tax audit? I was researching this, and they say the main purpose of sales and use tax audit is to verify the accuracy of a business sales and use tax records, payment and compliance, and applicable tax and laws. I think my client meet these three issues, which is he filed sales and use tax return on time. He paid whatever he collect from his clients, and he was with the compliance with all the regulations and tax laws when it comes to the sales and use tax. I don't know, but when an auditor comes to a business and then you start doing the audit, automatically whatever the auditor put, automatically he will charge 10% interest for 3 years and 10% penalty that applies to the tax or the estimated tax. This is a very small business. It has only one cash register tape, 2 employees, and basically a refrigerator. And it comes up to total sales with a credit card around 800 to 900,000. Now this is for a 3 years period. Now the auditor assumed that all these sales are taxable. The other thing is he assumed that the credit card sales is not enough, so it's only 60% of the tax liability, which is, from my point of view, is inaccurate, because with 2 employees, how much sales you will make, how many sandwiches or how much products you will have to generate $1.5 million in sales. So an estimation of this tax liability is inaccurate. And I think the auditor made a big mistakes when he estimate the sales to be $1.5 million or whatever the numbers in the exhibit. I believe my clients report the taxable sales that he sells and he collect the tax. Any other numbers we do not agree with, and I don't think that it is fair from the tax agency to put $100,000 and more on the client just because the auditor choose to make an estimate on it. I think if you go with the information that we have on the records, which is basically they say they want all the books and records. For sales and use tax, I don't think that you need all books and records. I think the only thing you need is how much sales you do, how much taxable sales you have, and how much tax you collect. These are the three means that you can accurately find out how much tax the business is supposed to report. Any other things, it will be a supplement. I was reading that the information that the auditor make is only an estimated information. It's not based on the accurate information that is in the record. And I think any estimation should not be admitted by the court. My clients reported the right information, and I think we should take whatever record that report, not the estimated things. Plus the penalty and the interest should be waived, because this is first time audit. We're supposed to educate people. We are not supposed to just say, oh, Now you owe 100,000, and now you have to pay 10% penalty. And now if you didn't have the money, you are out of business. And if you're out of business, we don't care because it is what it is. Thank you.
Okay, thank you. Does that conclude your presentation?
Yes, ma'am.
Judge Brown, did you have any questions for the appellant?
I may have a question. If I can ask, one of the issues concerns the fixed assets that were transferred when to the new owner. I wanted to ask about, and I understand that appellant disputes the estimate of the cost of the fixed assets that were transferred. I wanted to ask what evidence you can point us to in the record that shows what the fixed assets were consisted of. Like I'm looking, for example, at the photos that appellant submitted. Are those part of the fixed assets?
These are the only fixed assets they have. They have only one refrigerator, a big one for display, and the other refrigerator is a small one. It does not cost less than $1,000 if it's used. And I don't know why they are caring too much about a small business that has asset like that when they come to the transfer. Usually, when there is a big asset, we're talking about 100,000 asset, then we care about it. But a very small business like this, you can see that this estimate is the only thing is I say it's inaccurate. That's all. So basically, it's less than $1,000.
I also wanted to ask about your request for relief of interest.
Mhm.
In CDTFA's exhibits, their Exhibit H has a timeline of all of the course of how long the audit took. Did you review that document, Exhibit H?
No, but I know now it's already 6 or 7 years in interest, and I think it will equal almost half of the tax liability. And I don't know, they said by the law they cannot do anything about the interest, but I think this is, I mean, it's basically a tax liability, another tax liability.
Okay, that's all I have right now. Thank you.
Thank you, ma'am.
Thank you, Judge Brown. Judge Kim, did you have any questions for the appellant?
I don't have any questions at this time.
Okay,
you.
thank you. So we are going to move on to CDTFA's opening presentation. Mr. Samar Wickrama, you have 30 minutes. Please begin when you're ready.
Thank you, Judge. Ellen is a California corporation that operated a restaurant in Concord, California, serving food and beverages. Ellen commenced business on March 22nd, 2014, and ceased operations on November 15th, 2018, when the business was transferred. The restaurant was open daily with a seating capacity for approximately 20 customers. The department audited Pelham's business for periods April 1st, 2015 through September 30th, 2018 and October 1st, 2018 through November 15, 2018. During audit periods, Pelham reported total sale of around $341,000 and claimed sales tax reimbursement included in total sale of around $28,000, resulting in reported taxable sale of around $314,000. And this is shown on Exhibit A, page 45, and Exhibit B, page 27. During our presentation, we will explain why the department rejected Pelham's reported taxable sales, why the department used an indirect audit approach. How the department determined Pelham's unreported taxable sales for both audit periods. Why the department recommended a 10% negligence penalty for both audit periods, and whether the department is recommending relief of interest for any periods. During audits, Pelham failed to provide complete sales records. Pelham did not provide complete documents of original entry, such as cash register Z-tapes, guest receipts, credit card sales receipts, or sales journals for either audit period. In addition, Pelham failed to provide complete purchase invoices or purchase journals. Pelham was unable to explain how it reported its sales on its sales and use tax returns. Pelham was also unable to explain what sources it relied upon to file its sales and use tax returns. Therefore, the department did not accept Pelham's reported taxable sales and determined that Pelham's record was such that sales could not be verified by a direct audit approach. The department completed 4 verification methods to verify the accuracy of Pelham's reported taxable sales. First, the department noted Pelham's average daily sales during the first audit were very low, and this is shown on Exhibit A, page 55. Second, the department obtained Pelham's federal income tax return for years 2015 and 2016 from the Franchise Tax Board and found that the Pelham did not report 75% of the sales listed on the federal income tax returns. And when comparing reported sales to cost of goods sold, the department calculated a negative reported book markup. Third, the department calculated a rent ratio of around 60%, which is unusually high. And this information is shown on Exhibit A, page 58. Finally, the department obtained Pelham's credit card sales data for the period April 2015 through December 2017 and found that the Pelham did not report more than $600,000 of credit card sales during that period. And this is shown on Exhibit A, page 61. Pelham was unable to explain the reasons for low daily sales, federal income tax return sales differences, negative reported book markups, high rent ratios, and credit card sales differences. Therefore, the department used a credit card sales ratio method to determine audited taxable sales for both audit periods. Because Pelham did not provide complete sales information, the department was unable to determine Pelham's credit card tips and credit card sales percentages. Moreover, Pelham refused to allow the department to conduct site observations, which the department could have used to obtain this information, as well as analyzing Pelham's business practices and determining whether Pelham made non-taxable sales. And this is shown on Exhibit A, pages 10, 24, and 25. The department used Pelham's customer base, location of the business, items sold, selling prices, and federal income tax return data to determine a very conservative credit card tip ratio of 5% and credit card sales ratio of 60%. Phelan did not provide any reasonable information to determine a higher credit card tip and credit card sales percentage. Phelan failed to provide credit card merchant statements or 1099-K forms to establish credit card sales for both audit periods. Therefore, the department obtained Phelan's credit card sales information for the period April 2015 through December 2017 from his internal sources. And these are shown on Exhibit A, page 52. The department used a total credit card sale of around $892,000. The estimated credit card tip percentage of 5%. The estimated credit card sales ratio of 60%. And applicable sales tax rate factors to determine audited total sale of around $1.3 million. And these calculations are shown on Exhibit A, page 51. The department had no reasonable information to determine that Phelan made any non-taxable food sales. Also, Phelan did not provide any reasonable documents to demonstrate that it sold any non-taxable food items in its restaurant. Therefore, the department determined that none of Phelan's sales qualifies as exempt food sales to go because more than 80% of his sales were food products and more than 80% of his foods were taxable. Phelan failed to provide documentation separately accounting for non-taxable sale of cold food for off-premises consumption in a form suitable for consumption on his premises. As such, the department considered the audited total sale of around $1.3 million to be Phelan's audited taxable sales for the period April 2015 through December 2017. And this is shown on Exhibit A, page 51. The department then compared the audited taxable sales with reported taxable sale of around $243,000 to determine unreported taxable sale of around $1 million and corresponding error rate of around 434% for the period April 1st, 2015 through December 31st, 2017. And this is shown on Exhibit A, page 51. For the period January 2018 through September 2018, the department used the overall reported taxable sales and an error rate of around 434% to determine unreported taxable sale of around $264,000. And this is shown on Exhibit A, page 50. In total, the department determined unreported taxable sale of around $1.3 million for the first audit period, April 1st, 2015 through September 30th, 2018. And this is shown on Exhibit A, page 50. Phelan also did not provide any information for the second audit period. Therefore, the department used a reported taxable sales and an error rate of around 434% to determine unreported taxable sale of around $43,000 for the period October 1st, 2018 through November 15, 2018. And this is shown on Exhibit B, page 33. Phelan filed a notice of closeout on December 19, 2018, requesting closure of his seller's permit effective November 15, 2018. Since Pelan did not provide escrow information, the department determined the fair market value of $20,000 for sale of fixed assets based on the size of the Pelan's business. And this is shown on Exhibit B, page 34. In total, the department determined unreported taxable sale of around $1.4 million for both audit periods. And these are shown on Exhibit A, page 47, and Exhibit B, page 32. The department found that the determined unreported taxable sales was reasonable based on information reported on Pelan's federal income tax returns. In 2015, the ratio of daily expenses to reported daily sales was 325%. In 2016, 552%. And these calculations are shown on Exhibit A, page 58. This clearly indicates that the Pelan did not report all its sales on its sales and use tax returns for both audit periods. And this is shown on Exhibit A, page 58. A similar analysis was made comparing daily expenses to average audited daily sales. In 2016, the ratio of daily expenses to audited daily sales was 94%. And this is shown on Exhibit A, page 58. Based on this analysis, the department concluded that the audited taxable sales were reasonable. When the department is not satisfied with the accuracy of the sales and use tax return file, it may rely upon any facts contained in the return or upon any information that comes into the department's possession to determine if any tax liability exists. A taxpayer shall maintain and make available for examination on request by the department all records necessary to determine the correct tax liability under the sales and use tax laws, and all records necessary for the proper completion of the sales and use tax returns. When a taxpayer challenges an notice of determination, the department has the burden to explain the basis for that deficiency. When the department's explanation appears reasonable, the burden of proof shifts to the taxpayer to explain why the department's asserted deficiency is not valid. The audit calculation of unreported taxable sales based on the best available information was reasonable. Pelan did not agree with the audit finding for either audit period. During appeal process, Pelan claimed that it is entitled to an adjustment for cold food to go for both audit periods. As support, Pelan provided 3 sales summary tapes for 3 days and 2 pictures. And these are shown on Exhibit A, pages 68 and 69, and Pelan's Exhibit 2 and 3. The department analyzed the information and ultimately rejected it. Upon examination of those sales summary tapes, the department noted that the Pelan did not provide any individual sales receipts or any other information to corroborate the figures listed on those sales summary tapes. Regarding 2 pictures Pelan submitted as evidence of their cold food to go during audit periods, Pelan did not provide any corresponding sales receipts or evidence that customers purchased any of those cold food to go. Further, Pelan's pictures alone do not prove that the Pelan is not subject to the 80/80 rule. Therefore, the department finds that these documents do not support Pellen's contentions. Pellen also contends that the unreported taxable sale of fixed assets is overstated. Pellen did not provide any documentary evidence to the department to support that the transfer of business to new owner did not include the sale of fixed assets. Additionally, Pellen did not provide any information to support that the unreported sale of fixed assets is overstated. Therefore, the department rejected this contention. The department imposed a negligence penalty based upon its determination that the Pellen's books and records were incomplete and inadequate for sales and use tax purposes. And because Pellen failed to accurately report its taxable sales. The department generally does not impose a negligence penalty when the taxpayer has not been previously audited. Nevertheless, even in connection with the first audit, imposition of a negligence penalty is warranted if there is evidence establishing that any bookkeeping and reporting errors cannot be attributable to the taxpayer's good faith and reasonable belief that its bookkeeping and reporting practices were in substantial compliance with the requirement of the sales and use tax law or regulations. Relevant factors such as general state of the books and records and the Pellen's business experience must be considered. And when the evidence clearly shows that the understatement is due to negligence, then the penalty applies, even when the Pellen has not been previously audited. Specifically, the department noted that the Pellen did not provide complete records for both audit periods, and Pellen failed to provide documents of original entry to support his reported taxable sales. Pellen's failure to provide complete books and records for audit periods are evidence of negligence. In addition, the audit examination disclosed unreported taxable sale of around $1.4 million, which, when compared with the reported taxable sale of around $314,000 for both audit periods, resulted in an error rate of around 440%. This high error rate is additional evidence of negligence. Finally, Pellen is requesting relief of interest for audit periods due to unreasonable delay in processing of these audits. The department performed an analysis of these cases and the specific time spent during audits, appeals, and settlement process. And this is on Exhibit H. Pursuant to this review, the department determined a relief of interest for the department recommends the relief of interest for the month of October 2019. In addition to October 2019, the department also granted an automatic interest relief for the periods for March 2020 through June 2020 for COVID-19 pandemic impacted periods. Based on the foregoing, the department determined the unreported taxable sales based upon the best available information. The evidence shows that the audit produced reasonable results. Pellen has not provided any reasonable documentation or evidence to support adjustment to audit findings. Therefore, the department requests appeals be denied. This concludes our presentation. We are available to answer any questions the panel may have. Thank you.
Thank you for your presentation. I don't have any questions at this point. Let me check with my co-panelists. Judge Brown, did you have any questions for CDTFA?
I suppose I will just ask this same question or on the same topic that I asked appellant about the $20,000 estimate for the transfer of sale of fixed assets. I want to ask CDTFA if there's anything in the evidence that we can look at that indicates what fixed assets were transferred and that would support that amount.
Judge Brown, if you refer to Pellan's Exhibit 2 and 3, it listed, okay, give me 1 minute. Based on the pictures, we see two refrigerators, the large one and a small one, and also toaster I can see, and also a rice cooker, and also the capacity, because this restaurant has a capacity for 20 customers. So the table, chairs, and cooking equipment. So the taxpayer never provided documents. So these are the only information that we have in the exhibits. And based on the size, based on the size of the restaurant, and based on the capacity, and based on the credit card sales that they made, 20,000 is a reasonable amount for these taxpayer.
I think that's all I have right now. Thank you.
Thank you, Judge Brown. Judge Kim, did you have any questions for CDTFA?
I have no questions for CDTFA. Thank you.
Okay, thank you. Mr. Shahati, you have 5 minutes for your rebuttal.
Yes, ma'am. Let me start with the CDTFA has the 1099-K information for all the businesses in California. What does that mean? That the sales on credit card, they have access to it instantly, which means we are talking about 2018 and we are in 2024. So all this tax that he just mentioned is estimation, which means it's based on whatever they have records. And what I'm saying in this audit, my client did not report all the total sales. He reported the taxable sales only, and he paid what he collect from customers. Any other sales are non-taxable sales, and he did not collect any tax on these items. If the CDTFA think that my client did not report the right amount, why did they wait 3 years before they show up to tell him, oh, by the way, your tax return for first quarter 2015 is wrong or is underestimated? Especially we are talking about $1.25 million, actually more than $1.25 million. Why they waited all these years? Then after 3 years plus, they come, oh, by the way, in 2015, you report the first quarter second is wrong. And now we have 3 years. Now you owe $1.5 million in taxable sales. And now not only that, you have to pay penalty and interest. I think that is unfair for any businesses, retail in California that deals with the CDTFA. If there is an issue, you should address it. You don't need to wait. If somebody owe me money, I don't wait 3 years before I tell him, oh, by the way, you owe me money, I need to collect it. I think this audit is all estimation. I think my taxpayer paid the right amount of taxes that he collects. And I think just look at the furniture. They assume it's 20,000. A refrigerator, a used refrigerator doesn't cost even $300. They want to make it 20,000. That does not make any sense. That will conclude my rebuttal.
Okay, thank you. Mr. Shahati, you stated that your client didn't report total sales, but he or the client just reported the taxable sales.
Yes, ma'am.
Did your client keep track of all their sales somewhere? And do you have those documents?
He has only one cash register tape. It's not like a big business, that's what they think. It's only one cash register tape, one credit card that he has in his business. We are not talking about businesses that have 5, 6 cash register tape, and it's a very small corner business that has a very limited like sit down, because majority of the sales are to go. You can see the credit card sales. It's a very small business. I don't know why they think it is just making it as a big, it means that they owe that much money.
Okay, thank you.
Thank you.
Judge Brown, did you have any further questions for either party?
I don't have anything further. Thank you.
Thank you. And Judge Kim, did you have any questions for either party?
No questions. Thank you.
Thank you. We are ready to conclude this hearing. Today's hearing in the matter of Excel Food Services, Inc. is now adjourned and the record is closed. The judges will meet and decide your case later on, and we will send you a written opinion of our decision within 100 days. Thank you, everyone, for attending.
Thank you,
Thank you.
everybody, for attending. I appreciate you listening.
Thank you, Judge.
Thank you.
Have a beautiful day.
Thank you, you too.